So good day everyone, my name is John Luis Patiño, second year BS Criminology at Negros Oriental State University. And today, we're gonna tackle about Module 4 under our subject CA200. So the title of our lesson for today is Institutional-Based Corrections, Structures, Management Standards, Programs, and Services in the Philippines. So before we start, let me introduce to you the topics that we will be discussed under the lesson 4. So first, institutional-based corrections, structures, management standards, programs, and services in the Philippines. And then, the two system-based approaches to corrections, the Bureau of Corrections, RA 10575. Next is the custody, security, and control of prisoners, care and treatment of prisoners, and the release of prisoners. Next, the Good Conduct Time Allowance or the GCTA, Prohibited Act subjects to disciplinary actions, and then the BJMP RA 6975. Next is the Republic Act 9263, Treatment of Special Needs or Unusual Offenders, and then the emergency plans. Next is the movement or transfer of prisoners or detainees, privileges of detainees and sentenced prisoners. Next, the Regional Rehabilitation Centers for Youth, the Child and Youth Welfare Code. And then last is the death row and the rule on the writ of amparo. So before we formally start, let me introduce you the objectives of this presentation. So after this presentation, audiences are expected to be more knowledgeable about the institutional-based corrections, structures, management, standards, programs, and services in the Philippines. Next is to understand the different functions of the institutional-based corrections and the different laws that transgress in the fulfillment of their roles. Next is to learn more about the operations in the institutional-based corrections, as well as their plans, procedures, preparations, and actions in order to be more effective or effective itself. So, last is audiences are expected to have prior knowledge about the Regional Rehabilitation Centers for Youth, the Children and Youth Welfare Code, the death row, and the rule of writ on amparo. So first topic is the institutional-based corrections, structures, management, standards, program, and services in the Philippines. So the Philippine correction system is composed on the institutions of the government, civil society, and the business sector involved in the confinement, correction, and restoration of persons charged for and or convicted of delinquent acts or crimes. The public sector formulates sound policies and the rules on corrections, penology and jail management, rehabilitation, and restoration. All prisons or penitentiaries, jails, and detention centers are under the direct control on the supervision of the government. So, more widely, not other and limited to, the Philippine correction system is always controlled by the government of the Philippines. So the correction system is always have been controlled by the government of the Philippines. Since then, every correctional facility has been established by our own government. And then, in the Philippines, there is a distinction between a jail and a prison. So, as we all know, jail is different from prison. Jail is defined as a place of confinement for inmates under investigation or undergoing trial, or serving short-term sentences. It is differentiated from the term prison, which refers to the national prisons or penitentiaries. By means penitentiary is to repent or to penitent to the mistakes that you have committed or the crime you have committed. Prison refers to the national prisons or penitentiaries managed and supervised by the Bureau of Corrections, an agency under the Department of Justice. Though we define jail and prison differently, both agencies are under the Department of Justice. Jails include provincial, district, city, and municipal jails managed and supervised by the provincial government and the Bureau of Jail Management and Penology, or what we commonly know as the BJMP, respectively, which are both under the Department of the Interior and Local Government, or the DILG. Municipal and city prisoners are committed to the municipal, city, or district jails managed by the BJMP. A district jail is a cluster of small jails, each having a monthly average population often or less inmates, and is located in the vicinity of the court, where the imposable penalty for the crime committed is more than 6 months, and the same was committed within the municipality. The offender must serve his or her sentence in the provincial jail, which is under the office of the governor. Where the penalty imposed exceeds 3 years, the offender shall serve his or her sentence in the penal institutions of the Bucor. So, there are 3 major functionaries involved in the Philippine correctional system, and these are the DOJ, DILG, DSWD. So first is the Department of Justice, or the DOJ. The DOJ is responsible for upholding the rule of law in the Philippines. It is the government's principal law agency, serving as its legal counsel and prosecution arms. Next is the DILG, or the Department of Interior and Local Government. So the Department of Interior and Local Government is the executive department of the Philippine government, responsible for the promoting of peace and order, ensuring public safety, and strengthening local government capability, aimed towards the effective delivery of basic services to the citizenry. And last is the Department of Social Welfare and Development, or the DSWD, which is also an executive department of the Philippine government, which is responsible for the protection of social welfare or rights of Filipinos and to promote the social development. The DOJ supervises the national penitentiaries through the Bureau of Corrections and then administers the parole and probation system through the Parole and Probation Administration. It also assists the President in grant of executive clemency through the Board of Pardons and Parole. So the Department of Interior and Local Government supervises the provincial, district, city, and municipal jails through the provincial governments and the Bureau of Jail Management and Penology, respectively. So the DSWD supervises the regional rehabilitation centers for youth offenders through the Bureau of Child and Youth Welfare. Consistent with its constitutionally declared policy, the state values of the dignity of every human person and guarantees full respect for human rights. And its obligation as a state party to someone, it must not of the international human rights instruments. The Philippine government has undertaken measures to improve the treatment of offenders. So, in the Philippines, we have 2 system-based approaches to corrections. And these are the institutional-based treatment programs and community-based treatment programs. So, the institutional-based treatment programs. Reformation and rehabilitation of inmates, as well as the preparation for the reintegration and community, are the ultimate goals of the programs. Prison inmates are most of the most disturbed, unstable people in the society. So most of the inmates have too little discipline or too much come from broken homes and have no self-esteem. They are very insecure and at war with themselves as well with the society. Most inmates did not learn moral values or learn to follow everyday norms. In order to rehabilitate criminals, we must do more than just send them to prison. For instance, this program could give them a chance to acquire job skills, which will improve the chances that inmates will become productive citizens upon release. The programs must aim to change those who want to change, those who are taught to produce useful goods, and to be productive are likely to develop the self-esteem essential to a normal integrated personality. The kind of program would provide many useful skills and habits and replace the sense of hopelessness that many inmates have. So, important for a prisoner is to have a will to change himself and giving him support to improve. Many of them do not know how to start a new life, such therapeutic community programs are the way, and they can enlighten their future. The Bureau of Jail Management and Penology, or the BJMP, has adopted Therapeutic Community Modality Program, or what we know as the TCMP, as a new approach to inmate management to require new glossary of terms relative to felons and introduction of a new way of life in confinement. So, the therapeutic community itself is a self-help social learning treatment model used to clients with problems or drug abuse and other behavioral problems such as alcoholism, stealing, and other antisocial tendencies, as well as working with a special group of individuals like those in jails. So, In this model, this client receives the information and impetus to change from being part of the community. So the expectation that the community places on its individual members reflects not only in the needs of individual, but also the social and support needs of the community. So, what is community-based treatment programs? What are the community-based treatment programs rather? So, community-based corrections in the criminal justice systems are programs that offer an alternative to jail, term for convicted offenders. This is based on the fact that convicted offenders will eventually return into the community and therefore they need to repair the damage done to victims of crime and reform the offender in order to reduce the risk of reoffending potential. So of course, I have already rephrased this and explained this in this slide, but also I would like to add that reformation in prison should always be established because it is important that before a prisoner is released from confinement and be reintegrated back into the society, it is important that he or she has already developed the needs and the skills and what is the requirement to live normally back into the society he once lived in. So, the proponents also believe that only a small percentage of these crimes committed necessitate capital punishment or incarceration. The petty offenders can also be punished using more humane and productive modes that consume fewer resources. Each program is discussed in terms of definition, history, purpose, administrations, problems, cost effectiveness, and applicability to juvenile programs. In contrast to institution-based corrections, community-based corrections is geared to reintegration of the offender into the community. So the difference with the institution-based corrections to the community-based corrections, it is because it is more dependent on the community. So it depends on the society that we want the offender to live in order to live in a normal life, in order for him to develop himself, in order to be self-worthy or worthy of living back and be reintegrated back to the society or the community. So the issues in the community-based corrections are establishing program goals, selecting target population, soliciting funds, determining how best to introduce the program into the community, enlisting community support, and choosing staff. Forms of treatment used in community-based corrections include reality therapy, behavior modification, guided group interaction, and transactional analysis. So there are a lot of steps, and it is more or a bit complicated than institutional-based correction as far as I know. But so far, I think it would be useful in the correctional party in our country. So, what are the types of community-based programs? First is the parole and probation. So, probation and parole are privileges which allow criminals to avoid prison or to be released from prison after serving only a portion of their sentence. So, the goals of probation and parole are to rehabilitate offenders and guide them back into the society while minimizing the likelihood that they will commit new offense. So, probation. So, a judge may grant probation as an alternative to imposing a jail sentence. Probation is ordered when the circumstance and the seriousness of the crime suggest the probationer that it is not a threat to society and that incarceration is not an appropriate punishment. So, the probationer may freely live in the community but must abide by certain conditions of probation for a period of time specified by the court and report regularly to an appointed probation officer. Generally, conditions of probation may include living where directed, participating in rehabilitation programs, submitting to drug and alcohol tests, and maintaining employment. So, probationers may be required to show proof of the court that they have complied with all the conditions on probations. If a probationer fails to comply with all the required conditions, the court may revoke probation and require the probationer to serve jail sentence. Next is parole. So parole and probation is somehow different, but parole and probation combined also has its own use. So in contrast to probation, parole is a privilege awarded after an offender has served a portion of their prison sentence. Parole is granted after an offender has served a portion of his or her prison sentence. Thus, parole differs from probation in that it is not an alternative sentence but rather a privilege granted to some prisoners after a percentage of their sentence has been served. Parolees must abide by certain terms and conditions while they are on parole. These terms include living within state or country, meeting regularly with parole officers, submitting to drug and alcohol tests, and providing proof of residence and employment if a parolee violates the conditions of parole. His parole will be revoked and he will be re-imprisoned. So, one thing that we can see in reality nowadays, is when there's a drug offender, and he is on parole, we can see that he is always he is being monitored by a parole officer. Next is work release. So, some work release programs allow greater freedom for the prisoner, allowing prisoners who follow a Monday-Friday work week to attend work and live at their homes on those days, and serve their sentences 2 days at a time on weekends. Depending on the terms of the program, the prisoner may serve their sentence in a halfway house or home confinement while not working. Other work release programs can be offered to prisoners who are nearing the end of their terms and looking for a reintegration into civilian life, with a possible offer of full-time employment once the prisoner is released. So, furlough. So, a prison furlough is when a prisoner is allowed to leave prison and then return. So, furloughs can be escorted or unescorted. When the prisoner has to be accompanied by guards, often they are required to pay for these expenses of the furlough. So, furloughs are sometimes granted for medical reasons, to attend funerals, or to make contact for employment upon release. There is some evidence that furloughs reduce violent outbursts, although there have also been high-profile cases in which furlough prisoners committed crimes while on furlough, or returned late or remained at large. In the Federal Bureau of Prisons, furloughs are not considered a reward for good behavior, nor a means to shorten a criminal sentence, but are intended strictly to further correctional goals. Next is halfway house. Also called residential treatment center, term that is referred to community-based facilities that have been set up to provide access to community resources and offer transitional opportunities for individuals who are attempting to return to society as healthy, law-abiding, and productive members of the community after they have been found guilty of some crime. The concept of the halfway house is predicated upon the ideals of humanitarianism, rehabilitation, and reintegration, more often referred to as residential treatment centers. So, next topic that we will discuss is the Bureau of Corrections, or the RA 10575. So, the Republic Act 10575, it is the policy of the state to promote the general welfare and safeguard the basic rights of every prisoner incarcerated in our national penitentiary. It has also recognized the responsibility of the state to strengthen government capability aimed towards the institutionalization of highly efficient and competent correctional services. Towards this end, the state shall provide for the modernization, professionalization, and reconstructing of the Bureau of Corrections by upgrading its facilities, increasing the number of its personnel, upgrading the level of qualifications of their personnel, and standardizing their pay, retirement, and other benefits. So making it par with that of the Bureau of Jail Management and Penology. Custody, security, and control of prisoners, care and treatment of prisoners, release of prisoners. So first is custody. So custody is the state of physical holding or controlling a person or piece of property. So, or of having the right to do so. So a person who has custody over property or other person often has affirmative duties to protect and care for those in charge. In law, custody is used in criminal and family law. So basically what we see in movies or in films, when you say in custody, you are being confined, but not confined in prison or jail, but it is some way of saying that someone has you. No, when you're when an officer says you're in custody now. Oh. So in criminal law, a person is in custody when after being arrested or convicted of a crime. Oh, what this we can see this in movies and films, and when they are held in jail or prison, such persons are under state control until they are acquitted of their alleged crimes. So usually, the prisons we will get in custody are prisons accused of committing a crime. So persons in state custody are limited in their liberties and dependent upon officers to meet their needs. As such, officers owe a duty to care to anyone in custody to ensure their health, wellness, and safety. Property might also be taken following a person's arrest during the booking process. All personal effects such as clothing, jewelry, money, phone, or any other such items are held in police custody until the person's release. Most property in custody is safeguarded until reclaimed by its owner. So items considered evidence or contraband, however, are not returned after being taken into custody. Next is security procedures. So the backbone of a correctional facility is a good security. As a matter of fact, every aspect of custodial concern relates to security. If there is an operational area which marks the difference between prison custody and police security, as a rule in dealing with violations. It lays mainly in the rules of engagement. If a prisoner poses a challenge to corrective functions, as in escaping, the convict is presumed to be armed and dangerous and therefore must be pursued and subdued using any and all means with emphasis on fatal effects, meaning a shoot to kill. Move is presumed unless contrary orders are given. The constitutional presumption of innocence still shields the detainee from any untoward harm, whether the latter has caused the violation of otherwise. Under the precepts of correctional security, the heavy burden of securing not only the person of both staff and inmate is highlighted, including the integrity of the institution as well. Hence, correctional security must be handled by men of exemplary probity, and trained in the social science with exactitude. Admission of prisoner. So the formal correctional process begins from the time the accused is convicted, whether he is to serve time for violating an ordinance, in which case he would serve his sentence in local jails, or the revised penal code, in which case he would be sent to the National Penitentiary to serve his penalty. So, spending time in jail or being locked up while awaiting conviction is not a formal entry to the correctional system yet, and therefore the accused's presumption of innocence remains as it was, and he must be handled and treated as such. Unless the accused files a request for working detention, he cannot be compelled to don the prison jail or uniform nor subjected to the regimen an ordinary prisoner undergoes while under confinement. In the event that the accused is convicted for violating the revised penal code and is given a sentence with a maximum period of more than 3 years, he is to be transported to the National Penitentiary within a period of 60 days. So this applies to any other special laws. This period is to be reckoned on the date of commitment order as issued by the court. So, security procedures, the correctional authorities must be guided by and observe in due course the following. So, first is that those whose maximum sentences is below 3 years to serve in time in local jails. Second, those whose sentences is below 3 years but whose sentence includes a fine of more than 2,000 pesos for transfer to the National Penitentiary. Third, those whose maximum sentences is more than 3 years for transfer to the National Penitentiary. Fourth, it does those whose cases are still under trial to await judicial verdict and local jails or under bail. In some situations where national security reasons or court rules are invoked. So the person may be transferred to the National Penitentiary subject to orders issued by competent authorities such as the President, Congress, and courts. Fifth, those who commit violations in parole or executive clemency for transfer to the National Penitentiary to serve the remaining portion of the penalty. So those who are captured escapees from the National Penitentiary for transfer to the National Penitentiary to serve remaining portion of the penalty along with the penalty for evasion. Next is admission in prison. So by National Penitentiary is meant of any 7 prisons and penal farms under the Bureau of Corrections. So we have already discussed this and stated the 7 or the different prison and penal farms under the Bureau of Corrections, but I'm gonna explain it further later. So under Presidential Decree number 29, all penal colonies are declared as regular prisons. Hence, operationally, the Bureau of Corrections has been decentralized. Each of these prisons and penal farms maintains reception centers for newly received admitted correctional prisoners. So the following penal facilities are considered as regular prisons corresponding to the area where it is situated. First is the New Bilibid Prison in Montilipa City, for those sentenced to death regardless of place of convictions. Also for those from New Capital Region, Regions 1, 2, 3, 4, and 5. Second is the Iway Prison and Penal Farm in Puerto Princesa City, Palawan. So these are for the province of Palawan and regions 4 to A. Third, Davao Prison and Penal Farm, Davao del Norte. These are for people from Caraga, regions 9, 10, and 11. Fourth is Leyte Regional Prison in Abuyog, Southern Leyte, which is for regions 6, 7, and 8. And then fifth, Correctional Institute for Women in Mandaluyong City for all female national prisoners in the country. Sixth is the Sablayan Prison and Penal Farm, Sablayan Mindoro Occidental from Mindoro Province. And last, San Ramon Prison and Penal Farm in Zamboanga City from ARMM and Region 12. So here are the further procedures for admission and convictions. First is that to undergo the checking of commitment order, and then next is the strip search and inventory of personal property. So when you're about to be confined, you are also searched. Your whole body is being searched, and the confiscation of personal property that is with you, and then the registration. It is here where you're being registered to the system. And then identification, of course, you should be identified. And then the regulation of haircut and government issues. So there is a reason for this, because it also helps the system improve its order, no? And then next is the classification of prisoners. So as we all know, any prisoner is classified into different classifications in prison or jail. And then last is the uniform dress code. So when you are about to be confined, you are given the dress code, the uniform. And then care and treatment of prisoners. So here are the care of treatment of prisoners. First is that all prisoners shall be treated with respect due to their inherent dignity and value as human beings. Second, there shall be no discrimination on the grounds or race, color, sex, language, religion, or political or other opinion, national or social origin, property, birth, and other status. It is, however, desirable to respect the religious belief and the cultural precepts of the group to which prisoners belong whenever local conditions so require. And then fourth, the responsibility of prisons for the custody of prisoners and for the protection of society against crime shall be discharged in keeping with the state's other social objectives and its fundamental responsibilities for promoting the well-being and the development of all members of the society. And fifth, except for those limitations that are demonstrably necessitated by the fact of incarceration, all prisoners shall retain the human rights and fundamentals set out in the Universal Declaration of Human Rights, and where the state concerned is a party, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights, and the optional protocol thereto, as well as such other rights that are set out in other United Nations covenants. So 6 is that all prisoners shall have the right to take part in cultural activities and education aimed at the full development of the human personality. 7 is efforts addressed to the abolition of solitary confinement as punishment or to the restriction or its use such as undertaken and encouragement. And then 8, conditions shall be created enabling prisoners to undertake meaningful remunerated employment which will facilitate their integration into the country's labor market and permit them to contribute to their own financial support and to that of their families. Prisoners shall have access to health services available in the country without discrimination on the grounds of their legal situation. Then, with the participation and the help of the community and social institutions, and with due regard to the interests of the victims, favorable conditions shall be created for the reintegration of the ex-prisoner into society under the best possible conditions, and last, the above principle shall be implied impartially. So, releasing of the prisoner. So, prisoners are released from confinement for any of the following reasons. First is the basic upon expiration of his sentence after serving his sentence. Second, by the order of the court or of competent authority. After being granted parole, pardon, clemency, or amnesty, in the matter of the executive clemency and parole cases, the Director of Corrections submits the inmate's prison record to the Board of Pardons and Parole within the following periods. For commutation of sentence, at least 1 month before the expiration of 1/3 of the minimum period of the inmate's indeterminate sentence, and in special cases, at least 1 month. So, before the period specified by the board, for conditional pardon, at least 1 month before the expiration of 1/2 of the minimum period of the inmate's indeterminate sentence, and in special cases, at least 1 month before the periods as the board may specify. For parole, at least 1 month before the expiry date of his minimum sentence. So, further procedure for releasing of prisoners. First is we need to have the authority to release, and then the separation and placement center, proper identification before releasing, release of foreign national prisoner. So, release of foreign national prisoner also has its own procedure, the unique procedure, of course. And then release of prisoner with pending cases, and the prohibitions and releasing. Next is good conduct time allowance, GCTA, prohibited acts to subject to disciplinary actions, and the BJMP RA 6975. First, good conduct time allowance, or the GCTA. Republic Act 10592, or the good conduct time allowance law, allows for a reduction of sentences of persons deprived of liberty, or the PDL. So, depending on how well they abide by these rules and regulations inside any penal institutions, rehabilitations, or detention centers, or any other local jail. So, this law, in relation to the Republic Act 7659, or the death penalty law, which has been long abolished, reportedly does not cover PDL who have been convicted of heinous crimes as enumerated in RA 7659. These crimes were considered punishable by that for being grievous, odious, and hateful offenses, and which, by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity, are repugnant and outrageous to the common standards and norms of decency and morality. Excuse me. So, next is what are the prohibited acts that are subject to disciplinary actions. So, here are the prohibited acts that are subject to disciplinary actions. Participation in illegal sexual acts, public display of pornographic materials, obscene language, and displaying any behavior which might lead to disorder or violence. Possession of articles posing a threat to prison security, or maligning or insulting any religious belief or groups, giving gifts, selling, or engaging in barter with anybody. So, next is gambling, loitering, rendering personal services to or requiring personal services from inmates. tattooing himself. So I'm not sure, but in my perception, in the perception widely in people, some correctional institutions allow tattoos, or I might be mistaken. So engaging in business or profession from within, disobeying lawful orders of prison authorities, threatening anybody either on verbal or written form, and possession of any communication devices. So, after being subjected to disciplinary action, so we're gonna tackle about the types of discipline and what are the grounds of disciplining a prisoner or a detainee. So, procedures for handling disciplinary cases. So, a written complaint shall be filed with the superintendent by the aggrieved inmate or by any inmate on prison personnel having personal knowledge of the incident. The complainant shall sign the complaint and shall describe the violation names of possible witnesses. So the superintendent conducts initial investigations, and if the complaint is found to have basis, shall endorse the case to the Board of Discipline for hearing. Third, the Board of Discipline shall decide on the case within 5 working days after the termination of hearings. After the hearing in summary in nature and not bound by technical rules of evidence. Fifth, the inmate charged shall be allowed to present evidence in the hearing, and decision of the Board of Discipline is subject to review and approval by the superintendent, whose decision is final. So the decision of the Board of Discipline is still subject, but the superintendent's decision is the one that is final. So what are the disciplinary measures? First is caution or reprimand, and then second, cancellation of privileges. For example, if you have privileges that are given onto you inside prison, you will be discarded by them. And then third, the deprivation of GCTA or the good conduct time allowance, especially because you are subject to disciplinary action. You should be deprived of this GCTA, which enables you to have further privileges in prison. And fourth, change of security classification, especially depending on the and in the actions that and the rules that you have violated. So the BJMP RA 6975. So as one of the 5 pillars of the criminal justice system, the BJMP was created to address growing concern of jail management and penology problem. Primarily, its clients are detainees accused before or court who are temporarily confined in such jails or undergoing investigation, waiting final judgment, and for those serving sentences promulgated by the court here and below. Excuse me. As provided for RA or Republic Act number 6975, the Jail Bureau is mandated to take operational and administrative control over all city, district, and municipal jails. The Bureau has 4 major areas of rehabilitation program, namely livelihood projects, education and vocational training, recreation and sports, and religious spiritual activities. These were continuously implemented to eliminate the offenders' pattern of criminal behavior and to reform them to become law-abiding and productive citizens. So, although the workplace of the Jail Bureau is confined inside the portals of jail to safeguard PDL, or the persons deprived of liberty, nonetheless, the Bureau has an inherent function of informing the public of jail operations and other matters concerning the corrections pillar of the Philippines. Coincidentally, being new and growing Bureau, BJMP aims to keep the public abreast of information regarding jail management and penology. Republic Act 9260, Treatment of Special Needs or Unusual Offenders and Emergency Plans. So Republic Act 9263. So RA 9263 provides that the Bureau shall be headed by a chief who is assisted by 2 deputy chiefs, one for administration and other for operations. So this is for Bureau of Jail Management Penology. So one chief director of staff, of whom appointed by the President upon the recommendation of the DILG Secretary, from among the qualified officers with the rank of at least senior superintendent in the BJMP. The chief of the BJMP carries the rank of director and serves a tour of duty that must not exceed 4 years. So unless extended by the President in times of war and other national emergencies, officers who have retired or are within 6 months from their compulsory retirement age are not qualified to appointed as jail director or designated as BJMP chief. So the second officer in command of the BJMP is the deputy chief of for administration. So the third officer in command is the deputy chief for operations. So operations and administrations, that is the use of the second officer in command of the BJMP. And the fourth officer in command is the chief of directional staff, of all whom carry the rank of chief superintendent. They are assisted by the directors of the directorates and the national headquarters, who carry the rank of at least senior superintendent. The BJMP operates and maintains regional offices in each of the administrative regions of the country, headed by a regional director for jail management and penology. So next is treatment of special needs or unusual offenders. There are certain groups that are in particularly vulnerable positions in prisons and would therefore need additional care and protection. Some people may experience increased suffering due to inadequate facilities and lack of specialist care available to address their special needs in prisons. So the prison environment itself will exacerbate their existing problems. This includes prisoners with mental health care needs, prisoners with disabilities, PWDs, or older prisoners. Some are at risk of abuse from other prisoners and prison staff due to prejudicial attitudes and discriminatory perceptions entrenched in society itself, which are more pronounced in the closed environment of prisons. So those under sentence of death constitute a special category. They have particular needs relating to anguish caused by sentence itself and the intense psychological distress caused by isolated conditions in which they are held often for years or decades. So here are the treatment of special needs or unusual offenders and the laws that protect them under the United Nations. So first is the Universal Declaration of Human Rights, Article 2, which contends everyone is entitled to all the rights and freedoms set forth in the Declaration without distinction or any kind, such as race, color, sex, language, religions, political or other region, national or social origin, property, birth, or other status. Next is the International Covenant on Civil and Political Rights, or the Article 26 of the United Nations. All persons are equal before the law and are entitled without any discrimination to the equal protection of the law. In this respect, the law shall prohibit any discrimination and guarantee to all persons equal and effective protection against discrimination on any grounds such as race, color, sex, language, and etc. So International Covenant on Economic, Social, and Cultural Rights, Article 12. The state parties to present covenant recognize the right of everyone to enjoyment of highest attainable standard of physical and mental health. So of course, even though you are in prison or jail, your health and physical and mental health shall always be observed and should be attained at the highest standard. Movement or transfer of prisoners, detainees, privileges of detainees and sentenced prisoners. So, a prisoner can be transferred at any time. Prisoners are responsible for telling their family where they are. Common reasons for transfer include access to services and facilities, rehabilitation and progression to a lower security prison. The prison is inducted to a new person and property and approved telephone list transferred with prisoner. Towards this end, of center prisoner may be transferred to a lower security prison. Misconduct to a lower security prison may result in a transfer to a higher security prison. So, in order to request a transfer, a prisoner may want to transfer to another prison to be closer to their family of their home community. A prisoner who wishes to be transferred should speak to their case manager and ask for a request form. So only if your request form will be approved, only you can be transferred to another state prison. Privileges of detainees and sentence prisoners. So first is the right to be free from personal abuse and the right to be protected against the following: any deprivation of his basic needs under normal situations, especially the daily basic needs of any human being, and corporal punishment, especially because it is no longer allowed, corporal punishment, and then use of physical force, and solitary confinement or segregation as positive measures. Two is right to good conduct time allowance, or the DCTA. Unless you have committed grave offenses, which is not available for GCTA, or which does not comply for GCTA or good conduct behavior, right to have access to the following as far as practicable: medicine and health services, rehabilitation program, visitation, for example, conjugal or your wife or your husband, and mail services, free legal services, and materials. Other privileges of detainees and rights of detainees is the right to exercise his religious belief. Most prisons have prison chaplains, and every prisoner or detainee has the right to practice his religious beliefs. Right to air grievances and complain through proper authorities. Right of women offenders to be personally attended, supervised by women officer. Without prejudice to male doctors, nurses, and social welfare officers from carrying out their professional duties in the institution for women. Next is the right of foreign nationals to communicate with their diplomatic and consular representative. And our next topic is the Regional Rehabilitation Centers for Youth and the Child and Youth Welfare Code. So what is the Regional Rehabilitation Centers for Youth? So the Regional Rehabilitation Centers for Youth is a facility to provide intensive treatment in a residential setting for the rehabilitation of CICL whose sentences have been suspended. It serves as a nurturing out-of-home replacement for children in need of rehabilitation. So by means, CICL generally means children in conflict with the law. So the general objective of the Rehabilitation Centers for Youth is to render treatment and rehabilitative services to children in conflict with the law in the Cordillera Administrative Region CAR to enhance their psychological, emotional, and psychosocial well-being. Specific objectives: assist the children in conflict with the law in gaining insights into their behavior and attitudes to help them become more productive and responsible individuals. Redirect their behavior and attitudes to help them more productive and responsible individuals. Provide opportunities to acquire social occupational skills and improve self-image. Provide activities that would help them develop trust for other persons. The Child and Youth Welfare Code. So, under Presidential Decree Number 603, otherwise known as the Child and Youth Welfare Code, issued in December 1974, legally defines special categories of youth, including youthful offenders, and directs the Ministry of Social Services and Development, or MSST. So, it is to provide comprehensive services to assist in youth development. And our last topics is the death row and the rule on the writ of amparo. So the death row. So death row, also known as condemned row, is a place in a prison that houses inmates awaiting execution after being convicted of a capital crime and sentenced to death. The term is also used figuratively to describe the state of awaiting execution or being in death row. So even in places where no special facilities or separate unit for condemned inmates exist. So in the United States, after a person is found guilty of a capital offense in states where execution is a legal penalty, not only in the Philippines, Philippines death row has been long abolished, or the death penalty has long been abolished. So the judge will give the jury the option of imposing a death sentence or life imprisonment without the possibility of parole. It is then up to the jury to decide whether to give the death sentence. This is usually to be a unanimous decision if the jury agrees on that. The defendant will remain on death row during the appeal and the habeas corpus procedures, which may continue for several decades. So, this is referred to as death row phenomenon. So, estimations reveal that 5 to 10% of all inmates on death row suffer from mental illnesses. So, some inmates may attempt suicide, even though before they're brought for death penalty. So, there have been some calls for a ban on the imposition of death penalty for inmates with mental illnesses, and also case law such as Atkinson's versus Virginia to further this. So, executions still take place for those with clear intellectual disabilities due to poor legal representation and high standards of proof. And our last topic is the rule on the writ of amparo. So, Section 1 is the petition. The petition for a writ of amparo is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee, or of a private individual or entity. The writ shall cover extra-legal killings and enforce disappearance of threats thereof. So, the rule on the writ of amparo basically revolves on petition. So, it is a petition that is to be submitted. So, Section 2, who may file the petition? The petition may be filed by the aggrieved party or by any qualified person or entity with the following order. So, the following order is any member or the immediate family, namely the spouse, children, parents of the aggrieved party. Next is any ascendant, descendant, or collateral relative, or the aggrieved party within the fourth civil degree of consanguinity or affinity, in default of those mentioned in the preceding paragraph, or any concerned citizen, organization, association, or institution, if there is no member of the immediate family or relative of the aggrieved party. So the filing of petition by the aggrieved party suspends the right of all other authorized parties to file similar petitions. So likewise, the filing of the petition by an authorized party on the behalf of the aggrieved party suspends the right of all others, observing the order established herein. So therefore, if someone has already submitted a petition, it abolishes the right of others to file so. So that is the end of my presentation. Thank you, and I hope you have learned a lot from me. And once again, my name is Patiño, and this is the CA200 Module 4. Thank you, and have a good day.